Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Hello and welcome to Network West Virginia's Legally Speaking. This program is designed to educate and inform you, our local viewers, about the legal practice in our great state and how the law can affect you. Each week on Network West Virginia's Legally Speaking, we will feature some of the most progressive attorneys in the state, and you'll hear direct from them on a wide range of issues. You'll also be able to ask questions and make comments for future episodes by using the Contact Us page on networkwestvirginia.com. You can also find us on Twitter at NetworkWV. And now the host of Network West Virginia's Legally Speaking, Amy Strobel.
Good evening and welcome to Legally Speaking on Network West Virginia. I'm Amy Strobel, joined by Brent Van Deysen of the Van Deysen Law Office, and tonight we're going to discuss protecting your home from a Medicaid lien. Brent, when I read a little bit of text from some of the seminars that you give, one of the comments that I read in there was that people actually become fearful to even attempt to apply for Medicaid benefits because they are so fearful about losing their home or having the state take their home. Excuse me, do you find that fear really does keep people away from pursuing what could actually help them?
Absolutely. I mean, if you've ever known anybody who's ever gone into a nursing home, you may have come away with the understanding that, oh, if someone goes into the nursing home, then the state takes their home.
Absolutely, I've heard that.
And this rumor has come about because of what the Medicaid program calls the estate recovery lien.
Okay,
so
what is this?
Sure, if we're going into a nursing home and you own a home, and if you are the last living owner on the deed, then you can keep the home and qualify for Medicaid as long as the home's value is less than $536,000.
Okay.
And as long as you intend to go home if you get better. So you can keep the home. At your passing, again, if you are the last living owner on the deed, then the state has the right to place an estate recovery lien against your home and get repaid out of the eventual sale of the home for up to the amount of Medicaid services provided at the nursing home on your behalf.
Okay, so even though you may have qualified for Medicaid and you could, I'm assuming, be at the nursing home anywhere from a month to several years, you, in essence, if you own that home, would end up paying that bill?
Exactly. The way the Medicaid liens work is just like this. So if I go into a nursing home, I'm the last owner on the deed to my home. I've spent through all of my other assets and just have the home. I qualify for Medicaid, and let's say I'm in there for 3 years, and that during that 3-year period of time, the state of West Virginia has paid $200,000 for my care.
Okay.
Then after my death, and this is the practice that's currently in place, the state then puts a lien against the home and can recover those funds from its eventual sale. So if I have left in my will that my home go to my children, they would inherit the home subject to the Medicaid lien.
Okay.
So if the home is worth $150,000 and if the lien is $200,000, then to satisfy the lien, the home has to be sold unless the kids want to keep the home. Then they would pay its fair market value to the state, effectively can cause the heirs to lose that home as an inheritance because it would have to be sold in order to pay off the lien.
Yeah,
so,
that's almost a heartbreaking situation if you think that's what your parents have given you, and maybe it's the home you grew up in, and we all know the memories that are made and how special a home is. You're forced to sell it. You either have to somehow find the money on your own or sell the home.
To pay off the lien, that would be correct. So while the state of West Virginia does not take your home if you go into a nursing home. The negative consequences are that if you are the last living owner on the deed to the property, then the state has the right to put the lien against the property at your death and then collect that Medicaid lien. Now, if the state paid $30,000 for your care and the home was worth $60,000, you know, they would not be able to collect the full value of the home. They could only collect up to the value of the amount paid for your care.
Okay.
But the lien does go against the home and does gather interest. So if it sits there and isn't paid off, then that's an issue. Now, there are certain exceptions when a lien is not going to be enforced.
Okay.
There are also current collection practices in which many homes escape a Medicaid lien simply because of their value, and there are many protective ways that you could make a transfer to protect the home as you're getting eligible for Medicaid, so that there's no right for the state to put a lien against the home.
Okay, so which one do you want to talk about first?
Let's first talk about what are the things you can do positively to take steps to protect the home from a lien.
Okay, great.
Okay.
All right.
So the first thing is, again, with the home, and in West Virginia, we've been blessed with an abundance of home ownership. I'd say the majority of individuals who find themselves going into a nursing home are homeowners. The home usually represents the most valuable asset that a person has, plus it may represent an asset that has the ability to provide a family member with a home of their own that they wouldn't otherwise have. So, you know, if you could imagine a situation where your child has worked their entire life in maybe low-paying jobs, or maybe worked at a really well-paying job, and then the company went bankrupt, and then the pension went bankrupt, and they lost their health insurance and have lost the ability for themselves to own a home in retirement, you know, being able to pass that home onto that child might be that child's only opportunity at home ownership.
Absolutely. And again, the whole emotional tie to that
Absolutely.
home. Okay.
You know, and the emotional ties that you mentioned, you know, maybe this home is the family farm that's been passed down from generation to generation. You know, maybe this is the home that Dad added on to over the years, room by room, and maybe this is the home where, you know, all the family reunions have happened and all the good memories are stored that you mentioned. So it's a valuable asset, it's an emotional asset, and it can even mean the providing a roof over the head of some family member.
And if you mentioned a farm, maybe it's their source of income.
Right.
Okay, so you really need to protect your home.
Absolutely. It's usually the one thing that drives people to come see me, whether they've come to one of my...
That's interesting. Okay.
Yeah, whether they've come to my free legal seminar and learned about the issue. I often get people even just coming to me and sitting down and say, Mr. Van Deysen, you know, I want to live in my home. I don't plan to sell it. I'm worried. I'm in good health. But if I go into a nursing home in the future, I don't want the state to be able to take my home. I want my kids to have my home. Can't I just add them onto the deed and give them survivorship rights?
And what's the answer to that?
You can. That is a legitimate way to avoid a potential Medicaid lien. Remember the 5-year look back, though.
Yeah.
That has to be done 5 years in advance.
Okay.
And in this manner that I'm referring to, adding the children onto the deed and giving them survivorship rights. When West Virginia, to give somebody survivorship rights, what's being referred to there is creating an arrangement called joint tenancy with rights of survivorship. And in that situation, yes, at your passing, the property passes to the children through the survivorship right provision, and that sort of arrangement avoids the state's right to put a lien against it. But that type of arrangement creates a current ownership interest in your home or your farm with your children now while you're living.
Okay.
which that could be devastating if one of your children gets in financial difficulties, like goes through a divorce, loses their job, loses their health insurance, and suddenly has a $30,000 hospital bill, and now they're being sued. And then a creditor of theirs could get judgment against your home simply because you wanted to add them onto the deed to avoid a potential Medicaid lien that you may or may never not encounter because, you know, maybe you won't need to go into a nursing home. And that's a really tough thing, because a lot of people react and do things based on what their neighbors and friends say. Well, when Mom went into the nursing home, we didn't lose that because we had gone to an attorney and he put us on the deed. So there is.
But it's not right for everybody.
It's not right for everybody.
Okay.
True. And it's not just that. You know, that is one way that you can protect a home in advance of a Medicaid lien. Another way, and I would argue a better way, would be to set up a trust agreement. And I will detail what a trust is and how they can be used in my next
in the next show. And yeah, we're going to take a quick break, and then we're going to talk about how this plays into protecting your home. So stay with us, and we will be back in just a moment.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Welcome back to Legally Speaking on Network West Virginia. Brent Van Deysen and I are talking about protecting your home from a Medicaid lien, an issue that many seniors are worried about when they start to consider nursing home care. Brent, right before the break, we're talking about the ways to protect your home, and we're going to talk about putting your home, and I may say this wrong, but putting your home into a trust as one way to protect your home. Please tell us more about that.
Sure. So basically, a trust agreement is a legal agreement that allows you to be able to have assets owned for your benefit without them being in your name. So if your name is Rose Smith, or if we have a married couple, Jim and Rose Smith, and they set up the Smith Family Trust, we're going to do a deed changing ownership so that their trust is now the owner of their home.
Okay.
The trust paperwork then says at their passing what happens to the home. So when the individual or individuals who set up the trust die, their trust documents will say, now the trust ends and the home goes to the kids.
Oh,
when you have a trust agreement established in this way, Jim and Rose Smith are the beneficiaries who have the lifetime rights to live in this home. The children don't have any ownership interest in the home until John and Rose Smith have passed away. And with this sort of setup, with the trust being the owner, if John or Rose need nursing home care in the future, the state of West Virginia does not have the right to put a lien against the home. But keep in mind the 5-year look back. Just like if you wanted to add your kids onto the deed in the manner I previously described, or setting up a trust, you have to do that when you're healthy, when there's a reasonable expectation that you can get beyond the 5-year look back.
And it sounds like this might be a safer option than listing a child as a co-owner on the deed, because in this case, the child's actions, if they lose a job, if they go through divorce, that home is not part of their assets. Is that correct?
Exactly. Your children don't have any ownership interest in your home until you pass away. So if they get in legal trouble during your lifetime, no problem. It doesn't affect you and your use and enjoyment of the home.
Is there any negative then to setting up a trust for the home?
The one negative I would say about setting that up is every trust has to have a manager.
Okay.
So in the case of a family like this, perhaps they would select whichever child is going to be the executor of their estate to be the manager. So if you decide to have your oldest son be the manager of, or as the executor of your estate, you would make them the manager of your trust. And when I say that that's a downside, if you then decided to sell your home, then you and the manager together list the home for sale and sell it. So it would have to involve the manager of the trust in the selling process, but other than that, that would be really the extent of their involvement.
Okay, so what do you recommend to your clients for which of the methods have we discussed is really the best one?
Well, you know, it's going to depend on the client's situation. You know, not all planning options are going to be right for any particular client. That's actually one of the reasons why I offer a free consultation at my law practice, because people can come sit down with me, share with me what their concerns are. I can listen to what their goals and objectives are, and then we can come up with a plan. So I don't mean to be evasive, but I don't want to try to say that, you know, everybody needs a trust or everybody should consider putting their child into a deed. For some people, it's just not going to be an appropriate planning mechanism. So what I think we ought to talk about now, because those are the pre-planning options that you can consider when your concern is down the road, what if I need nursing home care?
Yes.
What if you need nursing home care today and you have property that's owned in just your name?
Okay.
Okay, so we don't have the luxury of doing this planning and getting through the 5-year look back. So let's say we have a married couple, husband and wife, and let's say the home is owned just by the husband, or even if the home is owned jointly by husband and wife, and husband is going into the nursing home. To avoid this Medicaid lien from being attached to the home at husband's death, what we would do at that moment that he's going into the nursing home, do a new deed where the husband is going to transfer his ownership interest in the home to his wife. And we do not have to worry about the 5-year look back.
Oh, okay, great.
And here's why. Married couples can transfer assets between themselves, no 5-year look back, no penalty. So if the husband's going into the nursing home, he can simply deed his ownership in the property over to his wife. That way, when he qualifies for Medicaid to pay his nursing home bill, at his passing, the state does not have the right to put a lien against that home because he has deeded it to his wife.
Okay.
Now, having said that and having deeded it to his wife, if his wife dies before him and has a will that leaves everything to him, now it's back in his hands, and now the state's going to be able to put a lien against it after he passes. Not to mention, if he inherited financial assets from her, now he's going to have to spend those and disqualify. So you can see when we start to go down one of the branches on the planning tree, we quickly get to all the leaves and other components of that.
It's amazing how many what ifs and different scenarios apply. And I like how you answered earlier that you can't just give a standard answer to what's the best method. You have to sit down with people and talk through their unique situation, and then all these, what if this happens and this happens and this happens, and I like to say this too on any legal show. The conversations that we have and the advice we give is very generalized. You know, you always need to contact an attorney directly about your particular situation. But that being said, we are going to keep continuing to discuss this subject, but we are going to take a quick break, so stay with us.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Welcome back to Legally Speaking. Brent Van Deysen and I are discussing protecting your home from Medicaid liens. Brent, right before the break, we were going through a scenario on how to protect your home. And we were talking about a husband transferring the deed to the wife, and then we have an exception, like anything in this field. Now that the wife dies before the husband does, and we have problems. So what are some other scenarios you can use to protect your home?
Sure. So if you're going into a nursing home, you're a single person, no spouse living in the community, then, but if you have a child under age 21, you could deed the home to that child, no penalty, no 5-year look back. if you have a child of any age who is disabled. If you can get proof of disability, you can deed the home to that child, no penalty, no 5-year look back. So again,
another option.
Another option, okay. But if you find that you're going into a nursing home, you're a single person, your desire is to have your kids own the home when you pass away, or if you have other heirs, nieces or nephews, whatever, and you want to avoid the Medicaid lien, then there is another option. You could sell at that point to your children a 1% ownership interest in the home.
Okay.
And with that deed, join survivorship rights, and as long as your children pay the value of that 1%, there's no penalty, there's no 5-year look back, and the loan can be avoided. Here's how it works.
Okay.
So you're going into a nursing home, and the other transfer methods that I mentioned are not an option, and you want to avoid the lien. So if your home is worth $60,000, your children can pay you $600 to purchase a 1% ownership interest in the home. In the same deed, they get survivorship rights. So at your passing, then, the home passes to them and avoids the Medicaid lien. Now, in doing this, you are making the children current co-owners with you, which is important in order to avoid the lien in this case, but also necessary, because if you're in a nursing home qualified for Medicaid, you only get $50 a month to pay for pay your taxes and utilities and such. So now the children are co-owners with you in that home. They're going to have to step up and pay the taxes, utilities, insurance, and upkeep. And as long as the home can be kept until you pass away, then at that point you're no longer an owner, because of the survivorship provision, and the state has avoided, it will not have the right to put a lien against the home. So this is often a last-minute planning option that is available when all other options are not available. And in doing this, this is not something I recommend for pre-planning, because there are other options available for pre-planning. This is only something that should be considered as a last-minute, let's try to save it sort of thing.
Well, and I think the moral of the story there is that there is always an option. It's never too late to get in touch with an attorney.
Right. Now, you may think it's too late to get in touch with an attorney if your parent has gone into the nursing home, never changed the deed, and they die, and now you as executor of the estate get this notice from the estate recovery unit for the DHHR. Asking questions about the house that your parent owned to determine if they're going to place a lien against the home. So when I say it may not be too late, what I mean is this. If there was some reason because of family relationship and use of the home that the state should waive its right to collect that lien because of a hardship, then they will consider that. So a hardship may be that you have a spouse, you have a surviving spouse living in the home who is not an owner of the home. They can waive the right to collect the lien based off of that hardship. In other words, it would be a hardship to impose the lien and cause the spouse to have to move from her house. If you have a child under 21 or a child with a disability living in that home, again, they're going to grant our hardship exception. A little bit of a less clear exception is one where imposing the lien would cause a hardship or a disruption to the family unit. And where I have used this example is when a grandchild had moved into the parent's home and had, or to the grandparent's home, and provided years of care and service. That grandparent having passed away, no protective deed being done in advance. In that case, we showed where the grandchild had actually sold their own home, moved in with grandma, and for all those years provided care. So in that case, again, they waived the right to impose a lien. So even if you haven't taken care of it in advance, there may be an exception that applies. Now, if none of these exceptions would apply, you'd better make sure it was taken care of in advance. Now, I also want to comment on what the state is not doing regarding the collection of these liens. Right now, the state of West Virginia is not collecting Medicaid estate recovery liens against homes with a value of $50,000 or less.
Okay.
So the way the state is determining value is by looking at what the county assessor says the value of your home is. And if you look at your real estate tax ticket, there's a figure on there. Take the highest figure, not the lowest figure,
okay,
which is reduced for a homestead exemption.
Okay.
That highest figure is 60% of fair market value. Take that figure divided by 60%, that gives you the fair market value. If the home is $50,000 or less, right now the state of West Virginia is not collecting Medicaid liens against those homes, even though there's no exception that would apply under the hardship waiver. Now,
and quickly, we have about a minute left.
Okay.
Is this ever going to change?
It can change, and here's why. We as a state are required by the federal government to recover Medicaid liens against all homes regardless of value.
Okay.
So at some point, I believe the federal government is going to require that West Virginia place liens against all homes of nursing home applicants, and for that reason, you need to take action to be protective and be prepared.
All right, Brent, as always, thank you for joining us tonight on Network West Virginia's Legally Speaking. We hope any of our viewers with questions will contact us here at the station. Good night.
Thank you.
You've been watching Network West Virginia's Legally Speaking. The views expressed on this show are that of our guest attorney and not the host, sponsors, or advertisers, and should not be considered as personal legal advice. If you have a specific legal issue, please speak with an attorney in person. For more information on schedules, appearing on, or sponsoring this or any Network West Virginia show, please use the Contact Us page on networkwestvirginia.com.
It starts with something little, like taking a first step, and then another, and another. And if you do it, and your friends do it, and their friends do it, soon we'll be walking our way to awareness, support, and an end to Alzheimer's disease. And that would be big.
Grab your friends and family and start a team today. Register at alz.org.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.